Yo, what's poppin', man? What's to it? Y'all already know how the squad do it. You got to stay moving to get through it. I hope everybody is blessed, stress free. And if you ain't, start knowing you can so you can stop thinking you can't. And with that being said, let's get to this. Let's get to this. Let's get to this. Hold on. Hold on. Hold on real quick. Hold on real quick.
Fuck is these niggas talking about? I don't know. I step on shit. I do. Get the fuck out my way. The fuck is you saying? The fuck is you saying? I'm one of the hardest niggas out. They won't get no credit as long as you living, but let your ass down and they popping out. See, I'm on a mission, they act like they missed it, but once you complete it, they watching out. Remember that silence that you was required, so why the fuck is you talking now?
I just wanted to get that out the way real quick. Because let me ask y'all a hypothetical, right? So let's say, right, hypothetically speaking, you become a public figure, right? And while becoming this public figure, you've made a reputation and created this image for yourself, right? And now this is what it is, and this is who you are. Now the thing is though, right? While you was creating this story, right? It was somebody that you didn't know nothing about sitting over there writing down everything in this story that you done, right? And then boom, one day out the blue, that person that you didn't know was writing down everything in this story confronts you about everything that you created in this story, right? Now, that's what we got in this situation, right? See, what a lot of people is missing is this. That if the Fed started this investigation in 2015, this would mean that all of you have known him since before 2015. So that means you have seen and you have heard everything that practically went on in his life, right? So with that being said, there's a lot of things that you would know when you read this indictment to know if it's true or not, right? To know if it really holds any validity. Okay. Now, the thing is a lot of people want to act as if, right? Like this whole going to the feds thing is just this mythical creature and it's like, if your paperwork ain't this, then, you can be whacked by the morning. And it's like, y'all is basically telling another adult person that when you walk into this place, there will be people there who will force you to interact with them, whether you want to or not. And if you don't interact with them, then you will be harmed. This is literally how it goes. And that people who never saw you before in their life and know nothing of anybody in your case, that they're going to get justice in there for somebody outside that they know nothing completely about. Like this is basically how this goes. And it's crazy. It's crazy, right? That these two is actually in the picture together. You want to know why it's so crazy? It's crazy because one of the loudest mouths on the internet, when it comes to this type of thing and paperwork and all this, Crack 100, right? According to him, Pooh Shiesty's a snitch. Paperwork, everything, right? He's named names in his paperwork. Whack 100 has the work. He has the paperwork on Pooh Shiesty being a snitch. Now, if this is true, and you can't be a snitch walking the yard, then can somebody explain this picture? If you can't be a snitch in there, and the minute that you this, right? Then can somebody explain this picture? It would help a lot for me to know. Because this either means that Whack 100 is lying, or he's lying, as well as practically everybody else who says that, because if Pooh Shiesty is indeed a snitch, then that means that paperwork doesn't matter when you go to the feds. Now, if Pooh Shiesty's not a snitch, then Whack 100 is a liar. You know, it's kind of incredible. You know, it's kind of incredible, right? But imagine all of the acts being cataloged, right? Now, before we get into all of the paperwork and everything else, right? We gonna work this in pieces, okay? Okay. So first, I wanna play y'all something, because it kind of bothered me, because it's like, this is how strongly that you people feel, and it's like y'all supposed to be everything. I'm talking about just straight criminals. Y'all is criminals. Y'all is criminals. You know what I'm saying? And
very comprehensive report, and that
I want to help you out, all right? So we're gonna go to a clip, right? And in this clip, I want y'all to listen to what's being said.
He didn't mention him right there. When he went and sat down with that probation officer.
Hey, Byron, you know.
No, I don't, because you asking him to say the nigga name right there when it's 10 niggas on the conspiracy.
Cool, Byron. Let me ask you this, right? Because I got kicked for a second, and you told the people that if other people go to trial, Surf gonna have to give a detailed account of what happened. That he have.
That's cap.
Exactly.
Now, it's clear that boy, whoever he was, knows absolutely none of what he's talking about. But let's hear Byron, because I want y'all to hold on to what he said. Now let's hear what Byron said.
stop it right there for just a second, because that's not what I said. And these guys are experts at attempting to twist your words to fit their narrative. What I actually said was that after you plead out, you have to participate in what's called a PSR interview. If you participate in this PSR interview, you are required to give specific details, a detailed account. What they do is they cross-reference the information that you've pleaded guilty to with the information that they are asking you about during the interview, just to see if you're being honest. So what I was saying is, if the overt acts say that Cox and Warden conspired, then Cox is not required to say Warden's name during pleading out, because he's admitting to conspiring with other members as alleged in the indictment. And
Now, this indeed is true, but I want y'all to hold on to that, right? Because it's finna get real interesting. Oh, it's finna get real motherfucking interesting. See, like one thing my mom always told me, she said, listen, if you gonna decide to say something about somebody, you make sure that the shit that you say, whenever it goes to be fact checked, the only fact that they find is that you was telling the truth, right? I'm not here to do nothing but that.
They're not going to even call him in there. They're not going to call him in there, Byron. I bet you 10,000 that they will not call Sue Surf in that trial.
Charged with running a drug
I bet you that.
They can't do that. So
They can't call him in there, bro.
unless he named somebody already.
There it goes. My man got a brain.
That's why,
Man,
Byron. That's why. Hold on, Byron. Byron.
No,
Hold on. Let me say what I'm saying.
There it goes.
No,
Let me say what I'm saying, Byron. Byron. Let me say what I'm saying.
Look the shit up.
Byron. Okay, so listen. They can't. They could Google it. They go see exactly what I'm saying.
Look it up. That shit can be used.
Okay, listen to what I'm saying though, Byron. The reason why.
Now, right? What I want to know is this. Hey, yo, Wack, and everybody who see this, right? I'm gonna need y'all to tag him, send him this, because do that 10,000 apply to everybody, or is it just bro? Right? Because if it applies to everybody, my good sir, I would like my cash in dubs, crispy, 20s. You hear me? Because oh yeah, this is finna get real interesting. This is about to get interesting. Do you hear me? Hey yo, look. Then he said, yeah, my man got a brain. It's clear the fuck that you don't. If he has a brain and you're the one saying it and you're saying it to the shit that he said, you are a fucking imbecile. That is just bottom line. That's just the bottom line. That is just the bottom motherfucking line. But hold on though, man. Wait a minute. Let's delve a little deeper into this part right here, right? Because he allowed for them to make a real dumbass of themselves, right? And I want for y'all to hear the dumbass that they made of themselves. So then we can get into the other.
You know damn well they can't just assume a general statement of I'm conspiring with members.
There you have it.
To somebody specific.
That's
There
why
you have
told them
it.
that brother got
indictment has overt acts listed.
I need that nigga on the exposures
That's
right there. That nigga got a brain.
Man, listen, bro. So you telling me that him saying,
I'm telling you, I got 10,000. They will not call SUBTITLES down to that man's
man,
trial.
that shit crazy as
Let's
shit.
bet. Do we got a bet?
Listen, Wack, you a good spin man.
Do we have a bet?
This nigga was just looking for an out for his
Do
argument.
we have?
I just want to know, does this bet include everybody, bro? That's all. I just want to know, does this bet include everybody? Because if this bet includes everybody, gang, I just need you to hit me and just ask me where you can Zelle me my bread. That's all, you know. But so now let's hear this. Let's hear this.
You don't got to do nothing. He already copied what he copied to.
Accept the plea in the first place. You don't have to.
There you go.
Now I know a lot of y'all thought.
Now, did you hear that? That was the smart them. That was the smart them. Okay, well, cool. Let's make a little bit more fun of this one, right? Hold on. Hey, Byron, my bad, gang. I just got to use a little bit more of this conversation because these they was on this bitch like the Three Stooges. Y'all remember the Three Stooges?
I
They
with the
was on this
probation
bitch with
officer.
that body
Give a
double.
detailed account while they prepare your PSR. Look this shit up, nigga. You don't know what the fuck you talking about.
Okay, I just Googled it for you. No, you are not required to give a detailed account of what happened after you
There
plead
you
guilty
go.
to a federal RICO indictment. I
No,
did
don't
look it up.
ask that.
Everybody else Google it and look it up.
Hold
I'm
on.
telling you what I know,
Ask
man. You
when
lied to
you
them.
go.
You
You
lied to
ask
everybody
when-
telling them
Bro,
that they had
you
to give a
asked a
detailed
general
account. You did that for a
question.
reason.
No,
'cause you know
you
what
asked a
you first
general
said.
question.
Don't ask.
So now, you clearly can hear that he didn't ask about the PSR. In which case, this is what they would deem to be gaslighting, right? Did I use that word right? I hope I did. I don't like trying to use none of them dumb ass words because it seems like you just don't even use them bitches right? You know what I'm saying? Because it all sound goofy as hell. But you know, let's carry on. Last one. This the last one. After this, it gets interesting. Oh, it gets interesting. It gets motherfucking interesting.
You talk to the probation officer while preparing your PSR. Ask that.
Do you have to give names?
Do you have to give a detailed account?
Do you have to give names? I'm
Hell
asking you.
yeah, if you giving a detailed
Oh
account.
my.
Now, as y'all can see, these.
Okay. So now, right. After hearing all of that, right? Let's see, okay, if y'all can wrap y'all minds around this part. So now first we're gonna go to the everybody agreed to take pleas. Okay. So now, right? What y'all are looking at right here. Y'all see the date that say 12/7/20. 12/7/20. Now, you see it says document 1, right? Document 1. Okay. Now, it says document 1 because this is the very first document of the indictment. See, this is where the indictment started, Mr. Edmonds, right? Now, this right here. On or about January 7th, 2020, Essex County, the District of New Jersey, the defendant, Amir Edmonds, did knowingly and intentionally possess with intent to distribute fentanyl. 1, 2, 4, whatever, a Schedule 2 controlled substance, and cocaine, a Schedule 2 controlled substance, in violation of Title 21 United States Code, sections 841A, right? Now, use of a firearm in furtherance of a drug trafficking crime. Now, right, when they labeled it like that, this is what turned this federal, okay? This is what made this situation federal, right? On or about January 7, 2020 in Essex County, the District of New Jersey, the defendant, Amir Edmonds, during and in relation to a drug trafficking crime for which the defendant may be prosecuted in a court of the United States, namely the possession with intent to distribute of fentanyl and cocaine is charged in count 1 of this criminal complaint, did knowingly possess, use, and carry a firearm. in violation of Title 18, right? Now, this is what actually happened, all right? So now, on this date, bro's sitting in the car on the block, busting a serve, and boom, the law see him, right? They slide past him. He looked all startled and shit, you know what I'm saying? They pull over, get out, slide up on the motherfucking car. He starts fidgeting and shit. They search the motherfucker. They find all of the motherfucking drugs. They find the gun, and they find the $41 and a cell phone, right? Now, again, that was document 1, 12/7/2020, all right? Now, this is why I believe, right? Because do y'all remember when Surf first got popped? He said, one of his homies was talking and all of that shit, right? You know, had to be ratting on him. And, you know, when I got to this part, I say, oh shit, this could possibly be what he was saying. But then I noticed his name wasn't on there, right? Oh yeah. Because see, the first indictment, yeah, it was filed 4/28/21. See, now this is when the indictment came down. This is when the grand jury indicted these 3 people. Now, 4/28/21. This is literally a year and what? 4 or 5 months after or before Surf's indictment with the same people. So now we got the Edmonds guy in 2020, right? The end, December of 2020. And then by April of 21, we got these 3 people. Now you would say, right? Now it's all the same shit from the other indictment. Everything is the same. See, but what's different is the fact that this indictment only started with these 3 people. Now, you in a gang. The leader and the other people in your gang get federally indicted. What's your next move? Do you dip? Do you get up out of there? Do you leave? Right? I mean, because me personally, I would have saw the fact that they got indicted, and then I would have said, But see, then I started going back into some tape. And this was all around COVID time. Y'all remember what was going on in battle rap around COVID time and shit, right? It's around when caffeine slid into play and all that. And then you start seeing Surf like heavy. He was in rotation. It kind of made me think like, damn, I wonder if he was already getting set up for this because he knew. But then it's like, what if he was getting the money to try to help them, right? Not knowing that he's actually a part of this. Okay? But yeah, the original and the initial indictment was only a 3-person indictment. It didn't change until the next year, right? So now we move on to we're gonna go over to this right here, right? Okay. So now this one, right? Document 125, right? Filed 3/15/23. Jason Franklin, right? Please take notice that defendant Jason Franklin, by and through his counsel, Michael V. Calabro, appearing hereby moves before the Honorable Brian R. Martinotti, USDJ, seeking the following relief: severance from his co-defendants, disclosure of all Brady materials, access to grand jury minutes, disclosure of the names of all informants, preservation of the government's rough notes and drafts, redaction of post-arrest statements made by co-defendants. Now, why would he be asking for that? Why would he be asking for that? Now, what I want y'all to understand, and I want you to pay attention to, remember what date I just said this was filed, right? 3/15/23. But why would he be wanting that, right? Disclosure of co-defendants' statements intended for use at trial. Why would Mr. Jason Franklin all of a sudden be asking? Why would he all of a sudden, right, be asking for this? Disclosure of all discovery pursuant to Rule 16(a)(1)(g), 10 days prior to testimony. Preliminary hearing to determine admissibility of 404B evidence. Leave to join in motions of co-defendants. Suppression of evidence seized during a warrantless search. Leave to file additional motions as they become appropriate in support of this motion. Defendant relies upon oral argument. March 15th, 2023. Right? Now, why that's important? Why that's important is this paper right here. This paper right here. Now, see, this is document 116, right? This was filed 1/5/23. Notice of motion for an order vacating detention and setting conditions of release. See, so now this is where a lot of things get interesting, right? Y'all finna see and hear a lot of interesting things right here. So now, please take notice that at a date to be set by the court, the undersigned counsel for defendant Rajon Cox removed the court under 18 U.S.C. 3142 and for an order vacating detention and setting conditions of release. Please take further notice that in support of that motion, the undersigned counsel will rely on the letter, brief, and exhibit submitted herewith. A proposed form or order is also submitted herewith, right? January 5th, 2023. Y'all ready for this? I represent Rajon Cox, also known as Sue Surf, his performing art name. In the above reference matter, Mr. Cox is a successful rapper, an entertainer, and a lifelong New Jersey resident. He moves pursuant to 18 U.S.C. 3142 to vacate the detention order and be released on a combination of conditions that will reasonably assure his appearance in court and the safety of the community. In sum, Mr. Cox, who does not face a rebuttable presumption of detention in this case, proposes that he be released from pretrial detention under strict lockdown home confinement at his mother's and her wife's residence in Secaucus, New Jersey. I didn't know Surf Mom was married to a lady. That's crazy. Y'all be making fun of Verb. Like, y'all be talking about Verb Mom. Anyway, in addition, Mr. Cox proposes that his mother and her wife serve as his third-party custodians, and an additional close family has also offered to serve as third-party custodian. From a financial condition standpoint, individuals are prepared to co-sign a surety bond in any reasonable amount, and that bond would also be further secured by the posting of two separate pieces of real estate, both valued at approximately $450K. One piece of property is his father's principal residence in Vinland, New Jersey, and the other a three-family investment property in Irvington owned by a close family friend. We respectfully submit that these proposed conditions of release will reasonably assure Mr. Cox's future court appearances and alleviate any potential danger to the community. Now, this was one of the main reasons that I said Surf was broke. He didn't have no money, right? Because they know, you see, they say he's a successful rapper, entertainer, all this, so they know he makes legal money. So none of his money would have had to be forfeited, taken, none of the above, right? So it's not like he had to hide nothing and put nothing up and say he didn't have nothing. Like, bro, they know that you make this is where you get your money from. So it's not like they can come and say, oh, well, you illegally rapped for this money. Like, no, you made your money. And then, the properties. One of them is your pops, and one of them is a close family friend. So I would have to assume that Mama Surf don't own no property or don't have much collateral that she could have helped put up in your name. But another thing that you don't see is anything offered from Sue Surf himself towards his bond, right? Now, why wouldn't you be saying, you know, I mean, with as much money as you say that you had and bragged about, you would think that, okay, yeah, it should be something in that package from that, but whatever. So now, right, this is where it's gonna kind of fuck y'all up, right? Because check this out. Mr. Cox was arrested on October 14th, 2022. Made his initial appearance by video the following day. Mr. Cox had counsel appointed even though he is not indigent. Now, this is the thing, right? Indigent means you don't have money, no type of income, no type of nothing. But by him being a public figure, he can't say that he does not have money. So now it is on him, because on paper it says he makes a certain amount of money. So now, hey, if you don't got this, too bad that you have bad money management problems. But what we're seeing, you're not indigent. You have to get a fucking lawyer, right? But appointed counsel consented to detention on his behalf without prejudice. ECF number 67. Mr. Cox was arraigned on October 27, 2022 before the Honorable Susan D. Wigginton. Undersigned counsel was subsequently retained and entered a notice of appearance on November 28, 2022. ECF number 110. Now, all right, this is 1/5/23 when he has obtained a lawyer, okay? Mr. Cox is charged with 1 count of conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, 18 U.S.C. 1961, and 1 count of being a felon in possession of 2 loaded firearms pursuant to 18 U.S.C. 922. So now, if y'all saw the last video, I asked and I kept saying, you know, it doesn't. Where did the drugs go? Where did the drugs go? He had to be getting convicted of drugs too. He had to be pleading to drugs because in his factual basis in court, right? We all heard and saw him admit to conspiring on these drugs. But he didn't have to plead to it. And I knew they wouldn't have dropped it. So then now I see here that he was never charged. He was never charged in the first place with drugs. So now why would he be given a factual basis in court admitting to conspiring to move drugs? The indictment alleges membership in the Rolling 60s neighborhood Crips pleaded as the enterprise. The conspiracy count describes various and diverse actions by the defendants beginning in 2015 up until the date of the indictment. A substantive RICO count is not charged. Thus, the conspiracy count alleges that a defendant conspired that at least 2 or more racketeering acts will be committed in conducting the affairs of the enterprise. Specific activity relating to Mr. Cox is discussed below. Now watch this. We see he's charged. 2 things. Now, the original PTS report, this is just them side note things that in case you don't bullet notes and shit like that. But the original PTS report under paragraph 5 describes defendant's conduct during arrest as a risk factor. Sometime before the date of his arrest, separate counsel had contacted the U.S. Attorney's Office regarding the charges and surrender. The defendant did not surrender himself and on the date of arrest did not immediately come out of the residence. He remained inside and was in telephone contact with his mother, who also handles certain of his business affairs. Mr. Cox was thereafter arrested without incident. He was unarmed and had no drugs, right? So now, argument. Pursuant to 18 U.S.C. 3142, Mr. Cox is not required to rebut the presumption that there are no condition or combination of conditions will reasonably assure his appearance in court or the safety of others. Mr. Cox is not charged with any of the offenses enumerated under 3142E, 3B through E. Is not on release pending trial for any federal or state offense, and the indictment does not allege any controlled substance offenses that would expose Mr. Cox to 10 or more years of imprisonment. Not that it wouldn't expose him to prison, it just wouldn't expose him to 10 or more years of imprisonment, right? Okay, now, With respect to Mr. Cox's alleged involvement in controlled substance offenses, alleged in the overt acts section of the conspiracy count, there are 2 references from 2018 and 2020. First, Mr. Cox is alleged to have instructed, alleged, right? To have instructed someone to purchase a small quantity of MDMA on April 14th. The government does not allege that Mr. Cox's instructions to purchase the narcotic had anything to do with distribution to others. No, it just means that he was selling it. Okay, but that's something else. Mr. Cox is also alleged to have conspired on or about October 6, 2020 to sell marijuana. Now, this is alleged. He was alleged to do this in January. All right? Alleged. Accordingly, there is no rebuttable presumption that detention of Mr. Cox is necessary, and the government has the burden of demonstrating that no condition of combination of conditions will reasonably assure Mr. Cox's appearance in court and the safety of the community. Right? Now, Mr. Cox is fortunate to have the support of family and friends who are willing to open their home to him. Not go to his home. Not something not his. They're going to open their home to him and pledge real estate on his behalf and serve as his third-party custodians. Accordingly, Mr. Cox proposes the following conditions of release. Full lockdown home confinement at his mother's residence in Secaucus, New Jersey. His mother, Kimberly Smith, and her wife, Jacinia Roman, reside there together. Mr. Cox's mother and her wife will serve as his third-party custodians. An additional individual is willing to serve as third-party custodian. Beyond his mother, friends, and family members are willing to co-sign a surety bond in a reasonable amount to be determined by the court if the court requires additional co-signers. Right? Now, up until there, you've heard nothing that Surf is saying that he is giving up. And we know he didn't have to hide anything or, stash nothing because his money it's accounted for. He paid taxes. Y'all remember him bragging about that? This is a business. I am a business. Okay, well, yeah, so we know your money was good over there, so something wasn't right. Now, Mr. Cox's, we did see Diddy and all of them folks, when they put up their bail packages, Dirk put up his bail packages, all that. When they put up other people's money, they put their money up too. Bro put up nothing. Mr. Cox's father and a family friend, Dennis Jenkins, agreed to pledge real property located in Irvington and Vinland, New Jersey, valued at approximately $450K each. It should be noted that Mr. Cox's senior property is his principal residence, and Mr. Jenkins's property is a 3-family investment property. Drug or alcohol testing, supervision by pretrial services. We respectfully submit that foregoing conditions of release are adequate to reasonably ensure Mr. Cox's return to court and the safety of the community under the factors set forth. Right? Now, check this out. Although Mr. Cox is no doubt accused of serious crimes and likely faces a term of imprisonment should he be convicted, the advisory guidelines sentencing range, assuming a 3-point reduction for acceptance of responsibility, and Mr. Cox being in criminal history category, what's that, 4, 5? Or yeah, 5, 4, all right? Or whatever that is, could be as low as 33 to 44 months imprisonment. Neither the RICO charge nor the felon in possession of a firearm charge require a mandatory minimum sentence. Now, they're stating this because they're saying that, he ain't required to do a mandatory minimum this on each charge. There is no, so the judge can give him whatever the judge wants to give him, right? Okay, so now, and Mr. Cox will be able to provide a sentencing court with substantial mitigating evidence. Accordingly, Mr. Cox is not facing such a significant term of imprisonment that he would contemplate flight. The overt acts section of the indictment alleges additional criminal activity involving Mr. Cox beyond the already referenced above. Those acts are, right? An alleged shooting, 2017, right? Mr. Cox entered a plea on that. He pled guilty to that. So he has that. Now, this was just during the indictment, when they was investigating the indictment, right? He still has a conviction from when he was 18, right? He also, because the judge is going to see his complete criminal history. They ain't just gonna see what he did on this paper and all this. Yeah, what they got right here, they gonna have it on there. But yeah, he's still two felonies, right? Then you got the possession of the 2 guns, right? Then you got right here, June 26th, 2021, while traveling in a car in East Orange, Mr. Cox allegedly threatened another individual while displaying a firearm. Discovery has not yet been received regarding this allegation. Now, who would have been able to told them that that's what happened, right? Let me see if we need to even read it. Matter of fact, y'all can pause that to read it. Now, here we go. Mr. Cox's mother wrote him a letter. Now, I don't think we need to go into the letter unless y'all want me to go into the letter, right? Although Mr. Cox has a criminal record, this case represents the first time he has been charged federally and thus the first time he will be subject to the far more rigorous strictures of federal pretrial release, right? Now, these enhanced conditions of release, combined with the fact that over the last several years, Mr. Cox has built a career and life outside of criminal activity worth preserving, reduce the relevance of Mr. Cox's criminal past to determining whether conditions exist today that will ensure his return to court and the safety of the community. With that said, Mr. Cox's criminal history does contain an instance of bail jumping, nearly a decade old, that occurred when Mr. Cox was just 23. He promptly resolved that case and served a 60-day jail term. Mr. Cox also apparently has an outstanding warrant in Michigan relating to an incident that occurred there when he was 21. When he got caught with the gun out there. Yeah, he got caught with the gun out there, right? Now, this is the letter from his mom. Right? Y'all can pause to read that. But this is what I don't get. Fast forward to life's issues. Rajan was skipped from 4th to 6th grade. Then they wanted to take him from 6th to 8th grade. But his father did not think that was the best thing for his son. Rajan remained gifted and talented and completed out his middle school years. Rajan longed for his father, so he thought being a class clown would get his dad's attention, which it did not. Rajan and his goldfish ran away to go to his dad. To this day, I still blame myself for not making him come right back home. This is when life turned for me. When things started to get more than what dad can handle, he was ready to send him back to me to handle the issues that was created under his supervision. Rajan graduated one of the top 10 in his class at the age of 16 at Cherokee High School. He also did some college at Middlesex County College. Like, where did all of this other shit come from? Oh, man. Okay. Now, so now we understand that Surf definitely was only being charged with motherfucking that, boy, I tell you, right? Okay. So now let's move along, right? Let's go to this part, right? Now, y'all remember when I said that Franklin, the Franklin dude, right? What day did he put that thing in? What day did Franklin put that thing in, right? 3/15/23, right? 3/15/23. This is what he was putting in. 3/15/23. This is why he did that on 3/15/23. Document 135 filed 4/27/23. Application for permission to enter plea of guilty. Rajan Cox hereby certifies as follows. My full name is Rajan Cox, and I request that all proceedings against me be held in that name. I understand that the Constitution and laws of the United States guarantee me the right to be represented by a lawyer at every stage in these proceedings, including any trial on these charges, and that if I cannot afford to hire a lawyer, the court will provide one for me. I have a lawyer who is representing me in this proceeding. My lawyer's name is John C. Whipple. I am satisfied that I have had enough time to discuss this matter with my lawyer. How? He just got on. Y'all ain't. English is my native language. My formal education stopped after some college. I am employed as a music performer artist. I have taken no drugs or medication within the past 72 hours. I have never been a patient in a mental hospital or institution. I do not believe that at the present time I am mentally ill or mentally incompetent in any respect. I received a copy of the indictment. Before being called upon to plead, I have read and discussed it with my lawyer. I understand that the substance of the charges against me is that I conspired to commit racketeering and possessed firearms by a convicted felon. So this is where he takes notice of knowing that he's not even charged with any type of drugs. Hence the reason probably why. We're going to get to that. Waiver of indictment. My lawyer has explained to me that I have a constitutional right to be charged by an indictment of a grand jury, but that I can waive that right and consent to being charged through a criminal information filed by the United States Attorney. I understand that unless I waive indictment, I may not be charged with a felony unless a grand jury finds by return of an indictment that there is probable cause to believe that a crime has been committed and that I committed it. I also understand that if I do not waive indictment, the government may present the case to the grand jury and request the grand jury indictment. Okay, now this is all of the things that you see what I say NA, but now this is the where he get to pick and choose and say, well, the grand jury or these people, that's if he was given it. Now this is where he comes in. The guilty plea. I told my lawyer all the facts and circumstances known to me about the charges set forth in the indictment. I am satisfied that my lawyer understands the information which I have provided and that my lawyer has counseled and advised me on the nature of each charge and on all possible defenses that I might have in this case. In addition, my lawyer has explained to me, and I understand that if I enter a plea of not guilty or persisted in my plea of not guilty under the Constitution and laws of the United States, I would be entitled to a speedy and public trial by a jury of 12 persons on the charges contained in this indictment. My lawyer has explained to me, and I understand that at such a trial, the jury will be told by the judge that I am presumed to be innocent and that the government will be required to prove me guilty of the charges against me beyond a reasonable doubt. I understand that I would not have to prove that I am innocent, and I could not be convicted unless all 12 jurors voted unanimously for conviction. So all y'all just going in there planning on rolling over when this is how this goes, right? My lawyer has explained to me, and I understand that if I went to trial on these charges, the government would have to produce in open court the witnesses against me, and that my lawyer could confront and cross-examine them and object to evidence offered by the government, right? My lawyer has further explained to me, and I understand that I have the right to produce witnesses and could offer evidence in my defense at a trial on these charges, and that I would have the right, if I chose, to testify on my own behalf at that trial. But if I chose not to testify, the jury could draw no suggestion or inference of guilt from that fact. Now, right, when they say that if I went to trial on these charges, the government would have to produce in open court the witnesses against me. Every last one of the people who took a plea had the same thing done and said to them, that in open court, the witnesses against them. Now, him being the first one running into a plea agreement, right, is doing what? Making him a witness to whatever overt act he's being fucking charged with conspiring with the other person to do. So now, him taking this guilty plea, if Warden decides to go to trial, right? My lawyer has explained to me, and I understand that if I went to trial on these charges, the government, now the charges that they had Warden on, and y'all gonna see that, right? My lawyer has explained to me, and I understand that if I plead guilty to any charges in this indictment, and the judge accepts my plea, I waive my right to trial and the other rights set forth in paragraph 17, 18, 19, and 20 above. I am aware and understand that if my guilty plea is accepted, there will be no trial, and that's underlined. There will be no trial, and a judgment of guilty will be entered, after which the judge, upon consideration of my pre-sentence report. I understand The judge, upon consideration of my pre-sentence report, that's the PSR that was talked about in the beginning, will impose punishment upon me. I understand that if I plead guilty, the judge may impose the same punishment as if I had pleaded not guilty, went to trial, and was convicted by a jury. So now we have a person who shot somebody before, right? Because this is what he said. This is what his charges is, that he shot somebody before. He was charged with attempted murder and all of it. So the judge is going to see this, right? So what could he possibly say in his pre-sentence report that the judge could take upon consideration? Now, y'all see that when his lawyer said a 3-point reduction, a possible 3-point reduction, possible, that means that something will have to be done. And if it gets done, it's possible that this 3-point reduction can be given. My lawyer has also explained to me, and I understand that if I plead guilty, I waive my right not to incriminate myself. I understand that the judge will ask me what I did, and I will have to acknowledge my guilt as charged by setting forth my actions so that the judge is satisfied that I am indeed guilty. I understand that any statements I make at the time I plead guilty, if untrue and made under oath, can be the basis of a perjury prosecution against me. My lawyer has informed me, and I understand that the maximum punishment which the law provides for the offenses charged in this indictment, a maximum of 30 years imprisonment and a fine of $500K for the offenses charged in counts 1 and 3. My lawyer has further explained, and I understand that there is no mandatory minimum punishment of years imprisonment and no mandatory minimum fine. I understand that if I plead guilty to count 1 and 3 of the indictment, I face a maximum sentence on those counts of 30 years imprisonment plus an aggregate fine of $500K. My lawyer has additionally explained, and I understand that in addition to or in lieu of the penalties already discussed, I may be ordered to make restitution to any victim, right? I understand that I will be assessed $100 for each felony upon which I am sentenced and $25 for each misdemeanor. I hereby declare that no offer or agent of any branch of government, federal, state, or local, nor my lawyer, nor any other person has made any promise or suggestion of any kind to me or within my knowledge to anyone else that I will receive a lighter sentence or probation or any other form of leniency if I plead guilty. My lawyer has explained, and I understand that only the judge may decide what punishment I shall receive, and that if any person has told me otherwise, that person is not telling me the truth. With knowing this, and with knowing that you have no guarantees that this lawyer is going to do this, you are still willing to go into this plea. You did it because you knew that you was going to get this lighter sentence, and you knew what you was going to do would get you the lighter sentence. I understand that the sentence to be imposed upon me is within the sole discretion of the sentencing judge, subject to the provisions of the Sentencing Reform Act. I understand that in deciding what sentence to impose upon me, the sentencing judge is required to consider the maximum and minimum prison terms, fines, and terms of supervised release recommended under sentencing guidelines. I understand that the sentencing guidelines may authorize departures from the maximum and minimum guidelines recommendations under certain circumstances, right? I understand that the sentencing guidelines are advisory and that the sentencing judge must also consider the other statutory factors identified in 18 U.S.C. 3553A in deciding what sentence to impose. I understand that the judge has the authority to impose a sentence more severe up to the statutory maximum or less severe than the sentencing range recommended by the guidelines. Puffy went to trial, beat the RICO charge, was recommended by the government to only do 2 years. The judge smacked him over the head with more time. We have criminals. We have violent criminals. Okay. I have discussed with my attorney how the sentencing guidelines might apply to my case. I understand that the court will not be able to determine the sentence for my case until after the pre-sentence report has been completed and both I and the government have had an opportunity to read the report and challenge any facts reported by the probation officer, which makes Byron Blake absolutely correct from the beginning of the video. Let me see if there's anything else on here. No, that's immigration. That's not applicable. I hereby declare that I have not been forced, coerced, or threatened in any manner by any person to plead guilty to these charges, nor have I been told that if I refuse to plead guilty, other persons will be prosecuted. There has been a plea agreement entered into between me and the United States Attorney, Assistant United States Attorney Francesca. The plea agreement does exist in written form. I have read it or have had it read to me. The substance of the plea agreement is plea to counts 1 and 3 with guideline stipulations. The plea agreement does contain stipulations agreed to by the parties. I understand that my plea agreement sets forth a guidelines calculation, which I agree is the total guideline offense level applicable to me in this case. I don't know why they scratched that part out, but whatever. I understand that my plea agreement provides that under certain circumstances I have waived my right to appeal or collaterally attack the sentence imposed in this case. Meaning that if the judge decides to say, I don't want to go with, so what, they gave you this point reduction for you doing what you've done, I'm still want to give you 15 years. The judge could have did that. My lawyer has explained to me, and I understand that if the judge accepts from guilty plea under the plea agreement, including the government's proposal to dismiss charges or to not bring other charges, the judge is not bound to follow the other terms of the plea agreement, including the stipulations recommending that a particular sentence or sentencing range is appropriate or that a particular provision of the guidelines does not apply. I understand that if the judge does not follow one or blah, blah, blah. So many words. We all know that when you cooperate with the state, what the state or the government recommends, the judge usually goes with. Usually. Now, in certain cases, they won't. I brought up P. Diddy because they didn't. Why didn't they? Because there was nobody else to fry with P. Diddy. Nobody else gets fried with P. Diddy. So you know what? No, I'm going to give you this, right? But see him, he had other people. He had other people that he can fry, right? Oh, this is just his counsel shit. So now, right, we finna go to this part. We're gonna go to this part. Because, so just to show y'all, you know, I got it. I'm gonna show y'all. Plea agreement with Rajon Cox Jr. This is his whole. I got the whole goddamn, and this is page 1 of 12. It's a 12 page. I got the plea agreement that's coming in part 2 of this because this shit getting long. But before I get up out of here, what I am gonna show y'all is this, right? So I only saw one warden on this whole indictment, and I would have had to assume that it was this person, right? Now. This is what's crazy. Surf didn't tell, or none of this, and you were supposed to have been taking a plea. Well, sir, Mr. Cody, who came and spoke out, could you come back and speak out and tell us why August of 2023? Please take notice that the defendant, Amir Warden, by and through his attorney, Charles B. McKenna, will move this court at a time and place set by the court for the following relief: dismissing the superseding indictment against Amir Warden, and the alternative, severing Amir Warden from the other defendants, striking surplusage in the superseding indictment as to Amir Warden, granting Amir Warden's discovery request, ordering the government to provide bill of particulars, ordering the government to provide all Brady and Giglio materials, ordering law enforcement to preserve all rough notes and drafts, requiring the government to disclose any intention to use prior or bad acts evidence, permitting Mr. Warden to file additional motions if necessary, and permitting Mr. Warden to join in appropriate motions filed by his co-defendants, right? Now, as we scroll down here, and y'all can pause this to read if you want to, but I want to get to right here. Amir Warden has been charged in a single count of a 13-count indictment, while others in the indictment were charged with possession of weapons, possession with the intent to distribute fentanyl and cocaine, possession of weapons and furtherance of crimes of violence and carjacking. Mr. Warden was charged only in a racketeering conspiracy charge. Mr. Warden was only charged in the racketeering conspiracy, count 1. Okay? He is not alleged to have been involved with other counts in the indictment. In addition, Mr. Warden, unlike some of his co-defendants, was not named in the notice of special sentencing factors regarding count 1, which is the RICO conspiracy charge. Right? Now, if he's only charged in the RICO conspiracy, okay, and the indictment alleges that Mr. Warden was a senior member of the Rolling 60s, which the indictment alleges is a racketeering enterprise. The indictment, however, fails to allege a sufficient factual foundation for these allegations. The indictment alleges that Mr. Warden organized the transport of large quantities of marijuana from California and other places to New Jersey and elsewhere, and that he coordinated drug distribution, including heroin and marijuana in and around Irvington and Elizabeth. Although alleged to be a senior member of the organization, Mr. Warden is mentioned only 5 times in the manner and means section of the indictment, which spans 20 pages and 83 individual paragraphs. None of these is sufficient to demonstrate Warden's membership in the enterprise is detailed in the indictment. Of those 5 mentions in the manner and means section, 1 involves an alleged conversation about profiting from the sale of marijuana and shirts, and second involved the Instagram post where Mr. Warden was allegedly trying to collect the debt, where the other person acknowledged that Mr. Warden was owed money. So now we have Mr. Warden, who is only being charged with the RICO conspiracy. We have Mr. Cox, who goes in and gives a factual basis stating that he conspired with Mr. Warden and other members to move marijuana. Now, when he does that, Mr. Warden only being charged with the RICO, and the act that they're tying him to, one of the acts that they're tying him to has to do with Sue Surf. So now, if he fights his RICO charge and he goes to trial for his RICO charge, Sue Surf now has to come in. Sue Surf now has to come in and get on the stand and say, yes, I conspired with Mr. Warden, because this is why he gave the factual basis in open court. This is why they asked him in open court, and this is what he disclosed to the probation officer in the pre-sentencing report before he went to court. But slide back on me for part 2, because it gets, oh yeah, I don't even think I really got to do no more than this. I might just do a video where I just put all of the paperwork up and just let everybody have at it, if that's what they want to do. But yeah. Mr. Warden, you was lying, gang. Yeah, he bullied you into taking that plea for that conspiracy, and you got the same amount of time as him. Yeah, you got the same amount of time as him. You was only charged with one thing, and you got the same amount of time as him, and he got a 3-point reduction. Yeah. So, look, if you here and you've been watching this and you done watched it, like the video, man. Comment. Let me know what y'all thinking, how you feel, and if y'all want to see the rest of this paperwork. Until then, man, follow me on all platforms. Papanoleone, Papanoleone, Snapchat, Facebook, TikTok. Give a fuck. Also, go add me to your playlist wherever you listen to your music. YouTube Music, Deezer, iHeartRadio, Apple Music, Spotify. I don't care. Add me to it. You feel me? Subscribe to the channel. Ring the bell. And until next time, gang, I am out of here.